Hey there, my name is Sal Malhotra, principal attorney at Trishila. Today we're going to talk about the consent and coexistence agreements in trademark law. The path to registration is rarely smooth, but applicants and owners can utilize consent coexistence agreements as a useful strategy in the brand building process. Let's start with understanding what is the purpose of a coexistence agreement. A coexistence agreement exists primarily for two purposes: to avoid litigation or contested administrative hearings at the USPTO, or enable a party whose application has been or is likely to be refused by the USPTO to obtain a federal trademark. More specifically, the agreement is relevant to the market interface factor under consideration in the USPTO's likelihood of confusion analysis. You might say, Sahil, how is that different from a settlement agreement? Well, a coexistence agreement is one between a trademark owner and another entity where the owner consents to the other entity's use and or registration of a trademark that is same or similar to the owner's trademark in connection with certain goods and or services. It is generally a less combative version of a settlement agreement where few or no obligations or concessions are imposed. On the other hand, a settlement agreement could require a party to seize all use of the mark at issue, as well as any similar marks, license the mark, destroy or turn over existing inventory, acknowledge the other party's superior rights, make the other party whole, compensate for the alleged infringement by damages, royalties, attorney's fees. Likewise, a good coexistence agreement should describe why the parties believe the confusion is unlikely. Example, differences in the goods or services or channels of trade, sophistication of the purchasers, provide evidence that the party's decision is business driven, which came to a conclusion that there is no likelihood of confusion. List clauses where the parties identify a continued duty to avoid or minimize any potential confusion. The more details both parties provide, the better. It is important that the parties avoid a naked consent where little to no detail is provided, and the bargain was merely struck to benefit their own interests. As a senior user, this can be taken as a compliment as you've built a brand that somebody finds valuable. But as an applicant, it can often be an uphill climb to convince a senior user to consent to the applicant's use and or registration of their mark. On the other hand, a consent agreement only addresses the registration issue for the applicant without addressing any of the details usually included in a coexistence agreement. Usually, parties often choose the route of a consent agreement because they wish to guard against any admissions in the coexistence agreement that could be used in litigation. Consent agreements are cheaper, less time consuming, are a practical choice for most due to market reality, or the applicant is limited in its future expansion options. If you would like to know more about trademark coexistence agreements or consent agreements, and if they are right for you or need assistance with your trademark application or litigation matters, please feel free to contact me through the link provided below. Thank you.